if the president can violate the Constitution and there's no court that can enforce an order against him, then you really do have a dictatorship. There's no limits on what the individual can do.
The original idea of the founders was that there would be three branches of government that would have the ability to check the power of each other in order to avoid the rise of a dictator. This was the big innovation of America back in the 1770s. You want to speak to that and the importance right now of, now that particularly that Congress has surrendered, or at least Republicans in Congress have surrendered all their oversight power to Donald Trump, that the courts stand in that breach?
The framers of the Constitution were deeply distrustful of executive power. They believed, as you just said, in separation of powers and checks and balances. James Madison, in Federalist Paper number 10, said, and I quote, "The accumulation of all powers, executive, legislative, and judicial, in the same hands is the very definition of tyranny." Alexander Hamilton, in Federalist number 78, talked about the importance of judicial review. The words in the Constitution are meaningless unless they're enforced, and we need the courts there to enforce them.
So the mechanism of enforcement, I mean, the Congress can, pull money from the president or from the Supreme Court, Article 3, Section 2. They can even regulate, not just regulate the court, but arguably define what the court can rule on. The court has the power to, and they can oversee the executive branch as well, and investigate it and all kinds of things. The Supreme Court and all the inferior federal courts, the only power, my understanding is, the only way that they can actually enforce their decisions is through the power of contempt of court. Can you fill us in on that? Explain that.
The courts don't have, in the words of Alexander Hamilton, the power of the sword. They don't have a military to enforce their orders. They don't have the power of the purse. And so what they do have is contempt power. Courts can issue orders, and if anyone violates those orders, they can be held in contempt of court. There's criminal contempt that has criminal penalties. There's civil contempt where somebody's fined or put in jail until they comply with a court order. But without the contempt power, courts are really rendered powerless.
So here we have a Congress that has already surrendered its power to Donald Trump, and the court system that is sort of holding the line here. The Supreme Court, for example, has said that Mr. Garcia must be returned to the United States 9-0, and that's, the administration's ignoring that. So the only power the court has to enforce this is contempt. And along come the Republicans in the House of Representatives and say, we're going to blow that up too?
They put a provision into the large budget bill that says, in essence, that federal courts cannot use their contempt power in any case if a bond was not required with regard to a temporary restraining order, a preliminary injunction, or an injunction. And this applies to all court orders that have ever been issued. So generally, courts don't require bonds when there's constitutional cases against the United States government. It doesn't make sense to require Abrego Garcia to post a monetary bond to be able to come into federal court. But what this would say is to the order in that case, and every order in a school desegregation case, prison reform case, antitrust case that's ever been issued, it is from now on unenforceable by contempt if the judge at the time didn't require a bond. And as I said, bonds almost never have been required in suits against the United States.
And the way contempt would work, generally speaking, right now, and I'm not an attorney, but my understanding is that a judge could start with the lawyer who's standing in front of them, say the Trump administration lawyer who's defending their refusal to bring back Mr. Garcia, and hold that person in contempt and throw them in jail or fine them with progressively greater fines. And then they could reach beyond that even. And is it possible that they could even hold the administration itself in contempt or even the president in contempt?
Likely they can't hold the president in contempt because in 1982, the Supreme Court said that presidents can't be held civilly liable for that they do in discharging the duties of the office. And last July, the Supreme Court said a president can't be held criminally liable for official acts. But anybody else who violates a court order can be held in contempt. Agencies can, and at times have been held in contempt. And so what this would do is say no court orders against the federal government, against any level of government, against anyone could be enforced by contempt unless a monetary bond had been required. This would make all of the orders that have ever been issued unenforceable.
Wow. And tell me if I'm overstating this. Without congressional oversight and without the ability of the courts to enforce their own orders, it seems to me that we're left with one of these three branches of government essentially holding all the power, the police power, that, basically all the power, and that would be the president. Doesn't this, in essence, turn Donald Trump into a dictator?
It's not coincidental that Republicans are trying to limit the judicial check on the president at the same time that Donald Trump is claiming unprecedented executive authority. If the president can violate the Constitution and there's no court that can enforce an order against him, then you really do have a dictatorship. There's no limits on what the individual can do.
This is deeply shocking. And this is in this legislation that these guys are promoting. Why do you think it is that, to the best of my knowledge, you're the first person to have sounded the alarm on this, and there seems to be no interest among the American press in this. What's it going to take? Why would it be that this is just being treated like, it's just another little provision in the law?
I'm not the first person to sound the alarm. Others have recognized it. I think in answer to your question, some of it seems to be about a technical issue concerning civil procedure. It involves applying a particular rule of the federal rules of civil procedure. Some of it is that it's a small provision in an extremely large budget bill. Now, my hope is if it passes the House, and obviously I hope it won't, but then when it gets to the Senate parliamentarian will say that this isn't about budget at all. It therefore isn't properly in a budget reconciliation bill, which would mean it would then be subject to a Senate filibuster.
Oh, interesting. And so that would be, if we're reaching out to our senators, that would be something to encourage.
Well, I think what we most need to do is what you're doing, publicizing this so that people understand that it's there and the consequences of it. Again, the ideal would be that this gets stripped out of the budget bill in the House. But if it goes to the Senate, then the next most important thing will hopefully be the parliamentarian of the Senate will make a ruling on whether this is a budget matter. If it's not a budget matter, then it's not part of the reconciliation bill, and then it's subject to a Senate filibuster. The thing about it being a reconciliation is that reconciliation bills under the so-called Byrd rule are not subject to a filibuster.
Right. But although they can only last for 10 years. My recollection, and correct me if I'm wrong on this, is that during the last Trump term, the parliamentarian in the House refused to go along with some provision of some law that the Trumpies wanted, and they've replaced that person. They fired her, as I recall. To what extent is the parliamentarian in the Senate subject to political pressure? How hopeful are you that this person will be able to maintain their independence and strip this out of this legislation? I'm
very hopeful. I mean, the parliamentarians have traditionally been politically independent. There's a benefit to the Congress in having people make those procedural rulings who aren't making them for political reasons. Obviously, we're seeing so many unprecedented things. We could see an effort here to try to undermine the independence of the parliamentarian. But at this point, for this bill, I think that may be our best hope.
Yeah. We're speaking with Professor Erwin Chemerinsky, the Dean of the University of California, Berkeley School of Law, and author of more than 20 books. Any final thoughts on this?
Let me tie this together with something that was heard in the Supreme Court last week, and that's whether federal courts can continue to issue nationwide injunctions. Notice that what the Trump administration is trying to do is lessen the power of the federal courts to be a check, eliminating the ability of a federal court to issue a nationwide injunction. make it much harder to check the president. Limiting the ability of a federal court to enforce its orders by contempt would limit a check on the president. And I think at a time we're seeing a president claiming such unprecedented authority, we should be very wary of lessening the few checks that exist on the president, the few ways we have of enforcing the guardrails of democracy.